Okay, Shannon, put us on, please.
Okay.
Okay, this is the matter of Devin and Christopher Sauceda. Could I have each of you identify yourselves for the record?
Mayor Wade, Prosecutor's Office.
Amber Fader, MDHHS.
Mike Kelly, attorney for mom.
Michelle Arocha, DHHS.
Karen Lubeck.
Rebecca McCluskey, guardian ad litem.
And we're waiting for Ms. Taylor's audio connection to, Ms. Taylor, can you hear me? Well, I can see her moving around, but I can't hear her.
Good morning.
Good morning, Mr. Brown. Does anyone happen to have Ms. Taylor's phone? Oh, wait a minute. Looks like we might be connected. Ms. Taylor, your microphone is muted. If you could unmute it, please.
Hello?
Okay. Good morning. You can hear me now?
Yes.
Okay, very good. Mr. Kelly, will your client be entering a plea this morning?
Yes, Your Honor. She'll be admitting to the court that there was drug use within the home on her behalf, and the children were in the home, and she would like some assistance to obtain sobriety and for their return.
Okay. Give me just a moment. And are we expecting the father to appear this morning?
Your Honor, he was previously in jail at our last hearing. I have tried to reach him since then with no success, so I cannot give the court any guidance on that.
Your Honor.
All right.
I have the grandmother here, Matthew's mom, and she actually spoke to Matthew yesterday and confirmed that he would be on the hearing today, but he apparently is not.
A little early in the morning.
If someone has his phone number, I could give him a call and see if we can get him on that way.
Yep, Grandma is grabbing her phone right now to get his phone number for you.
I had
Okay.
just texted him.
517-257-9449.
Come on, Matt.
Your call has been forwarded to an automated voice messaging system.
Matt
Is not available. At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options. To send a fax, press 4 now. To leave a callback number, press 5.
Mr. Sauceda, this is Judge LaFlamme. Your case involving your children, Devin and Christopher, was scheduled for 8:30 this morning. Since we've been unable to reach you and you have not signed into our court hearing using Zoom, we are going to proceed without you. Okay. Well, let's take care of the plea first. Ms. Taylor, can I ask you to raise your right hand, please?
Yes, sir.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Katie Sue Taylor.
Ms. Taylor, you are the mother of Devin Sauceda, born December 3 of 2007,
Yes, sir.
and of Christopher Sauceda, born April 28 of 2009.
Yes, sir.
Was each child located in Jackson County at the time the petition was filed?
Yes.
If the court accepts your plea today, there will not be a trial, and you would therefore be giving up all the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in a petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you understand that you will be giving up all of these rights if I accept your plea today?
Yes, sir.
If the court accepts your plea today, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your children temporary wards of the court, place them with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your children with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you understand each of these consequences?
Yes, I do.
If your parental rights are terminated, your obligation to support each child will continue until a court modifies or terminates the obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and such a challenge can include any issues leading to the disposition, including any errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining the necessary court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions about anything I've told you so far?
No.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No.
Are you entering this plea of your own free will?
Yes.
Mr. Kelly, correct?
Yes.
Would you please establish a factual basis?
Ms. Taylor, would it be fair to say from the contents of the petition that you have an issue with using drugs?
Yes.
Would it be also fair to say that at times when you use the drugs in the household, the children would be in the household?
See, that's the part I have a problem with, because my recent charges and activities and stuff like that says that the kids were home, but no, they were not. That's the only part I have a problem with. I didn't do anything around my kids.
Not necessarily in front of your kids, but maybe they were in another room within the house and you were somewhere else.
I'm just gonna,
Ms. Taylor, you just muted your
sorry,
microphone.
somebody was calling in. I hit them. Well, yes,
I believe I have anything further, Your Honor.
So just to make sure we're clear, Ms. Taylor, do you acknowledge that at times you've been under the influence of drugs when your children have been in your care?
yes, sir. That I do agree with.
Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
I do accept the plea. I find that it was knowingly, understandingly, and voluntarily made. And I find that the record supports that one or more of the statutory grounds alleged in the petition are true. Mr. Way, are you prepared to move forward with testimony as to Mr. Sauceda?
I believe so, Your Honor. I would inquire whether we have a proof of service in the file before we get into testimony. I don't show one in my file, but they just put them directly in the file.
I will take a quick look. No, I am not showing a proof of service. So we don't have a summons served on Mr. Sauceda, so we're going to have to adjourn his adjudication until we can get him served.
I do believe, Your Honor,
Shan-
that we're prepared to do disposition as it relates to Ms. Taylor. Is that correct, Ms. Arocha?
Yeah, we're prepared for disposition on Ms. Taylor.
All right, well, before I lose sight of it, Shannon, can you give us a new adjudication date for Mr. Sauceda in 4 weeks?
I'm showing there's a proof of service summons for a father,
Ah,
6/25.
we don't have the hard copy, Matt, but apparently JIS shows that a proof of service of the summons has been filed.
I show one for
and it's-
6:30, yeah. I don't know if it's maybe, are we sure it's dad and not mom?
No, it says actually on here, the clerk's office docketed it as summons for Matthew Sauceda. So
Okay.
I'm just assuming it didn't.
Matt, I'm
June,
getting filed. I've filed motions, and more often than not, stuff is not getting in the file, and it's a problem.
all right. In any event, so Shannon, there is a mailing proof of service that on June 30th.
There should be a note on the proof of service, one of when I sent it to the prosecutor's office.
Oh, yeah, that was, I did see that. But that was on the summons itself. That wasn't on the proof. June 2nd, it was sent to the prosecutor's office for service. So, all right, well, the file reflects that there was service on June 30th. We will go ahead. Obviously, if that proof isn't discovered, he'll be able to claim a defect in the proceeding, but I'm going to assume the clerk's office is right. So before we do disposition, let's take care of adjudication of Mr. Sauceda. Who's your witness, Mr. Way?
Your Honor, I would call Karen Liebeck.
Ms. Liebeck, would you raise your right hand, please?
Okay.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your full name and then spell your last name.
Karen Lynn Liebeck, Liebeck.
Go ahead, Mr. Way.
I didn't get that.
Liebeck.
Thank you.
Yes.
Ms. Liebeck, are you the mother of Matthew Sacita?
Yes, I am.
Okay, and you are then the maternal grandmother or paternal grandmother of Devin and Christopher Sacita?
Yes.
And are you aware whether those Devin and Christopher were in Jackson County back on May 27th of 2020?
Yes.
Were they?
Were they in Jackson County?
Yes.
Yes.
Okay. Did you, the petition indicates that you spoke with somebody from Child Protective Services on May 21st, 2020 about your son's heroin addiction. Do you recall that?
Yes.
Okay, and what can you tell the court about Matthew's heroin addiction?
He's been a heroin off for at least 12 years.
Okay, the petition also indicates that you indicated at that time that he was actively using. Is that?
Yes.
And how do you know that?
Just by seeing him, I mean, you can tell.
Judge, I'm going to object. That assumes facts, not an evidence.
I can lay a foundation.
Go ahead, Mr. Wade.
Thank you, Anna. Ms. Liebeck, you said he's been a heroin addict for over 10 years.
Yes.
And what are you basing, have you had conversations with Matthew regarding that?
Yes.
Okay, has he made admissions to you regarding that?
Yes. I've had to call the ambulance before to revive him.
Over those 10 plus years, have you seen him while he was under the influence of heroin?
Yes.
Judge, I'm going to, and she has, that assumes facts, not an evidence. And she is not an expert in identifying somebody that's under the influence. Got to have a little more than that.
I think if he's admitted to her when he's under the influence and she sees how he behaves when he's under the influence, as a layperson, she can draw a conclusion as to whether or not he's behaving in that manner. So I'm going to overrule the objection.
Thank you, Your Honor. Ms. Liebeck, what do you observe in your son when he is under the influence?
That he's real drowsy. The way he talks different. He walks different.
And are those characteristics different than, say, when he's just tired, maybe?
Yeah. Yes.
Okay. Did you observe him back in April or May of 2020?
Yeah.
How often back then would you see Matthew?
He was actually staying with me until I caught him using again. I could tell he was using again, and I made him leave my home.
Okay. And how could did you observe him with the same characteristics that you'd previously seen when he was under the influence of heroin?
Yes.
Okay. And you also said that you caught him using?
Yes.
How did you catch him using?
With a needle in his hand.
Can we have a time?
Do you know when that was approximately?
Probably 3 years ago. Maybe.
Okay, did you catch him using sometime in April or May of 2020?
I didn't catch him, no, but he would come here and he looked like he would been using.
Okay. And that's based on, that was consistent with the 10 plus years that you've seen him when he's been under the influence?
Yes.
I have no further questions for Ms. Liebeck, Your Honor.
Cross, Mr. Brown?
No, Judge.
Any questions, Mr. Kelly?
No, Your Honor.
Ms. McCluskey?
No questions. Thank you, Your Honor.
Okay, thank you. Any further witnesses, Mr. Way?
Yes, Your Honor, I would call Amber Fader.
Ms. Fader, would you raise your right hand, please? Are you to swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name, spell the last, please.
Amber Fader, Fater.
Go ahead, Mr. Way.
Thank you, Your Honor. Ms. Fader, you were the petitioner in this case, is that correct?
Correct.
And were you the ongoing worker for Devin and Christopher Sacita?
Correct.
Were they found here in Jackson County at the time you filed the petition?
Yes.
Is Matthew Sacita, date of birth 2/10/1989, their legal father?
Yes.
During your ongoing case back in May of 2020, did you make attempts to reach Mr. Sacita to engage in the case?
I attempted to call him a few times, as well send a text message.
And were any of those attempts successful?
He had called and left a voicemail after hours. I was not successful in reaching him back. He also sent me a text message saying he was busy and he would call me, and again, he never did.
And was that back in late May of 2020?
Yes.
At some point around that time, on May 20, so the petition indicates that you received a voicemail the night after hours on May 26, 2020, is that correct?
Yes, I believe so.
Okay, and the next day on May 27th, 2020, was a decision made to remove the children from their mother?
Yes.
Did you make attempts to locate and reach Mr. Sacita on May 27th of 2020?
I attempted to call him, yes.
Were you able to reach him to come up with a plan to potentially take his children?
Prior to the filing of the petition, I was unsuccessful.
Were you able to reach him sometime after the petition was filed?
I personally did not. The on-call worker was made contact with him.
Okay. I have nothing further, Your Honor.
Questions, Mr. Brown?
Yes, Ms. Fader, who was the on-call worker that made contact with Mr. Sacita?
Sean Furlong?
Okay, and did you have conversations with, is that a him or a her?
Him.
With him, did you have conversations with him about his contact with Mr. Sacita?
He had informed me that he served the petition to Mr. Sacita.
Did he do any investigation, like view his home or take a drug test or anything of that nature?
Not at that time, no.
Okay, and why wasn't that done? To confirm or deny his drug use? Any idea?
I do not know.
Hello?
His purpose was to serve the petition where he was located at Karen's home. He was not instructed to do any further investigation.
Okay, and do you know why that?
After a petition is filed, because he wasn't the worker on the case, the intention was for me to follow up with Matthew for further information and investigation, but that contact was unsuccessful.
Did Mr. Sacita live with Ms. Taylor?
Sorry, what was that?
No, they did not live together.
Okay, but he was found at her home.
He was found at his mother's home, Karen's home.
Okay, thank you, Judge. Nothing further.
Questions, Mr. Kelly?
No, Your Honor.
Ms. McCluskey?
No questions. Thank you.
Any redirect, Mr. Way?
No, Your Honor.
Any further witnesses?
No, Your Honor.
Okay, let's have arguments. Mr. Way?
Your
I'm
Honor, based
sorry. Hold on. I jumped the gun. I made an assumption. I shouldn't do that. Mr. Brown, do you have any presentation?
No, Your Honor.
Ms. McCluskey, any presentation?
No presentation, Your Honor. Thank you.
Okay. Go ahead, Mr. Way.
Thank you, Your Honor. I would ask that the court adjudicate based on both Ms. Liebeck's testimony and Ms. Fader's testimony. I think Ms. Liebeck's testimony establishes she's dealt with, she's been forced to deal with her son's heroin addiction for over 10 years. She's able to tell when he's using based on a combination of things that she described. And she said that Matthew was acting in the same way, acting under the influence around the time that the children were removed during the investigation. And then Ms. Fader testified that she was unable to reach Matthew the following day when she was doing the removal of the children. That to me, we not only have drug use, but we have these kids being left without proper care and custody or guardianship at the time that the children are removed from their mother. So I would ask that the court adjudicate based on that testimony. Thank you.
Mr. Brown?
Judge, the only thing I can say is that Ms. Liebeck's testimony is historical. There's no evidence that he's currently using. I don't think a proper investigation was done, no drug test, nothing to determine the current situation as to whether he could take his child. So I don't think that the prosecutor has met the burden in this matter. Thank you.
Any argument, Ms. McCluskey?
No, Your Honor. I'll leave that in the discretion of the court. Thank you.
All right, I'm satisfied based upon Mr. Sauceda's mother's testimony and the testimony of the worker that granted there has been no test, which we would normally have in these circumstances, but it's kind of hard to test someone who doesn't make himself available. He was unavailable even to take custody of his children when they were removed from their mother. And has been evidenced even by his unavailability for his own trial this morning. Clearly, his mother has a sufficient past history to be able to form a reasonable judgment as to whether or not her son is under the influence of heroin. He's admitted to her that he does heroin. She's seen him actually in the process of injecting himself with heroin in the past, and she sees behaviors consistent with that past addiction leading up to the time at which the children were removed. I believe that provides a sufficient basis for the court to adjudicate as to Mr. Sauceda, and I do that today. And are we prepared to move forward with disposition as to both parents?
Yes, we are.
Okay, Ms. Aroka, what are your recommendations for disposition?
Okay, so it is recommended that Devin and Christopher remain in out-of-home placement and under the supervision of the Department of Health and Human Services. It further recommends that both have supervised parenting time with Devin and Christopher by DHHS or its designee. As for Ms. Taylor, it's recommended that she complete a psychological assessment and follow all recommendations contained within, successfully complete and show benefit from a parenting coach program, obtain, maintain, and show proof of a legal gainful employment, maintain a safe, clean, and stable home for herself and the children, participate and benefit from individual counseling, participate in a substance abuse evaluation and follow all recommendations, participate in random drug screens twice a week and screen negative for all substances. As for Mr. Sauceda, it is recommended that he maintain regular contact with DHHS and his probation officer as to his whereabouts. Participate and provide verification of services available to him from his probation officer. Complete a psychological assessment and follow all recommendations contained within. Successfully complete and show benefit from a parenting coach program. Obtain and maintain a safe, clean home for himself and the children. Participate in a substance abuse evaluation and follow all recommendations. And participate in random drug screens twice a week and screen negative for all substances.
Ms. Aroka, would you be kind enough to email that list of recommendations to Shannon?
I got it.
Yeah. Oh, okay.
Thank you.
Thank you.
Mr.
No worries.
Brown, do you have any objections to the recommendations?
Did you say?
Mr. Brown,
I'll leave that to the discretion of the court.
Mr. Kelly,
No objections, Your Honor. Thank you.
Ms. McCluskey,
No objection to the recommendation. Thank you.
given what the court heard today, those recommendations do indeed appear to be appropriate and properly tailored to the needs of these parents. So I will order them, and we will schedule our dispositional review hearing for
October 20th at 9 o'clock.
October 20th at 9 o'clock. Anything further on this file today?
No, Your Honor.
Oh, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Okay, next up.
Mom was supposed to be brought over in person for this hearing.
Okay, and Mr. Williams isn't here or in the waiting room. And we're early for the next one. Can you check with the jail and see, maybe they're gonna put her in a tunnel? In the meantime, I'm going to try to get a hold of Mr. Williams. Does anybody have his phone number?
Judge, I've got his cell.
Okay, go ahead.
He's still on live YouTube. I don't know if he wants that out there.
Oh, I hear you.
Let me just email Shannon.
Or me.
Okay, I'll shoot you an email.
Okay.
Just sent it to you. You should have got it.
Good morning.
Good morning.
Hi, this is Shannon from Judge LaFlamme's office. Judge is wondering where our 9 o'clock people are. We've got a 9 o'clock, a 9:15. Oh, we don't do jail people very often, so what do you need us to do? Yep, we want Hurl, you can bring Hurl and Chase together, because we've got their attorney here, both of them, so that would be great. Thank you so much. Okay, bye. Apparently we have to call if we want to.
Hi, you've reached Timothy Williams. Please leave me a message with your name, number, and the best time to reach you, and I'll call you back as soon as I can. Thanks for calling.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options. To leave a callback number, press 5.
Mr. Williams, this is Judge LaFlamme. We're scheduled for the Hayden Joyner matter, 9 o'clock this morning, and we're trying to reach you so that we can move forward with that. Please call me as soon as you get this message, or actually dial into the Zoom hearing. Thank you. Well, that's not encouraging. I will try sending him an email. All right, Shannon, you can take us off the record.
Mr. Way,
Mr. Brown.
are